Well, many companies, including agribusiness retailers, utilize customer loyalty programs. These rewards typically result in a cost to the retailer and a benefit to the farmer, triggering tax issues for both. Well, Roger McEowen with the Washburn School of Law joins us now to review the potential impacts. As always, Roger, thanks for your time here this morning. So how do the Treasury regulations address the treatment of rebates and refunds?
Well, good to be with you, Janet. Actually, there are two regulations that are relevant on this issue. And the IRS position is that a retailer cannot claim a deduction until the points are actually redeemed, because the event that fixes the retailer's liability occurs when the member reaches the minimum number of points for redemption and actually goes ahead and redeems those points. But if a retailer happens to be on the accrual basis, then a deduction can be claimed when the customers earn the rewards. That deduction is not deferred until the later year.
So what type of tax issues can this create for the customer?
Well, fortunately, normally the rule is nothing. Under the IRS rebate rule, customer rewards and credit card points are simply treated as a non-taxable purchase price adjustment. But there can be situations where that rebate rule doesn't apply.
Do you have an example for us?
Yeah, in fact, in the tax court last year, there was an incredible case. There was a married couple that put over $6 million on their credit card to buy Visa gift cards and money orders and prepaid cash reloads that they later used to pay the credit card bill. And they earned reward dollars for doing that, almost $300,000 of rewards in 1 year. And they didn't report the reward dollars as income, citing the IRS rebate rule. And the IRS said, no, that should have been reported as other income on the return. And the tax court agreed. They said, look, they were buying cash equivalents. There wasn't a product or service obtained in connection with the money orders and cash reloads. They were making money off of this.
Now, has there been any talk of reform in this area moving forward?
Well, the facts of that case were so egregious that the tax court actually indicated that they wanted to see some reform in this area, but nothing has happened yet.
Do you think there's any threshold level where concern should maybe kick in on this matter?
Well, if you're using a customer loyalty program to make money, that's then where you should really pay attention to that. You really should report the income from what you've earned in that situation, because that's an accretion in addition to wealth. We don't see this is the only case I've seen like this, and this is egregious. Most people aren't putting millions of dollars on their credit cards and abusing these customer loyalty programs like this. And so most of us don't have to worry. There's not going to be a tax impact at the customer level.
A lot more record keeping than I would want to mess with myself. Thank you very much, Roger, for taking the time to chat with us. Again, go online to washburnlaw.edu/WALTR for more information. Roger McEowen with the Washburn School of Law connecting with us today. Of course, we appreciate your time, Roger.